Trial. Trial is where the rubber meets the road. You've had an investigation that may have taken 6 months to a year. Charges were preferred against you. The Article 32 took place. The charges were referred. You had the arraignment. You had the motions hearings. You've been dealing with this for a year to a year and a half, and you finally have your day, your week, your month in court. It is where the rubber meets the road. There is a difference between attorneys and trial lawyers. And trial lawyers are someone that can actually stand up and argue and present the case and passionately find a way to win. And if everything's been done right, this is the best chance you have to win the case. At the trial, there's going to be a jury selection. That may take an entire day. That's where we're picking the jury, picking the members. There's a way to do that. That process can take 2 hours. It can take a day, but we want to make sure we have fair and impartial members who are going to decide the case. After that, the government's going to give their opening statement. They're going to try to make you look like trash, try to make you look like you are the worst human being in the world, and they're going to give this opening statement. After that, the defense. We have our first opportunity to present a compelling, reasonable, believable story to the jury. And from this point in time, it's critical that there's a lawyer up there advocating who actually makes sense, who has good presence, who can advocate for you, so a jury starts believing and buying that narrative right away. So it's something called confirmation bias. And what I mean by that is if a jury sees your lawyer get up, give this opening statement, and they say, yeah, that makes sense, we can get behind that, we believe in that, they are much more likely to acquit you than if you do a terrible job and then give a good closing argument. So it starts at jury selection and the opening statement. After that, the government's going to put on their case. That may take a day, it may take a week. They're going to call all of the witnesses. That could be NCIS, CID, OSI, CGIS. If it's a sexual assault, they'll call the alleged victim, and they'll put them on the witness stand to testify. They may call expert witnesses, DNA experts, experts in serology, digital forensics. There may be a slew of witnesses, and after they testify, we have the opportunity to cross-examine them. And it's critical that they go through the crucible of cross-examination so the truth comes out, so they have motives to fabricate. And if they're not telling 100% of the story, it comes out on cross-examination so the jury can see that, a jury can see that they're lying, and we work your story of innocence into each and every single witness. It's absolutely critical. After the government rests their case, they'll say they rest their case, and the defense then has the opportunity to put on a case of their own or witnesses. Now, surprisingly, sometimes the best cases I've ever done and a lot of acquittals I've had, I haven't called a single witness because the burden of proof is on the government to prove your case beyond a reasonable doubt. So if the government didn't do a good job, if I think the government's case is flawed, if I don't think they've met their burden, oftentimes I don't even put on a case and I put that burden on them, then we just slam them on closing arguments. But that's not every case. So if we do decide to put on a case, and I always say if you're going to put on a case as the defense counsel, you need a damn good reason to do it. And if you do, you call your witnesses, and it's the same process. We call the witnesses, and the government has the opportunity to cross-examine them. And for an accused, you do not have to testify. No defendant has to testify. And in many cases, even if we put on a defense, it doesn't make sense for an accused to testify. That's a very unique question that has to be looked at in every single case, but it doesn't always make sense. In some cases, it does. After we're done putting on our case, we rest our case. We go over, do what's called instructions. Instructions are where we go over the law with a military judge. We figure out what law is going to be given to the jury, and then the jury will have the law. Basically, what the law is, what are the elements of the offense, what are the defenses, and so on. Then we give closing statements. The government has the opportunity to go first and last because the burden of proof is always on them. So the government will stand up, they'll give some closing argument, trying to make you look like the absolute worst person in the world, and they'll go through that closing argument. That can take 30 minutes or an hour. And then as the defense counsel, we get one shot to make it count. One shot to take it home, one shot to wrap this up, put the bow on it, and get an acquittal. And if we've been doing our jobs right, we've been doing all of the work from the very beginning, so we're not trying to win it on the closing argument, but we're just trying to push it over the edge. So we'll stand up, give an incredible, passionate closing argument that's going to lead the jurors to the inevitable conclusion that you're not guilty. That may take half an hour, hour and a half, it just depends on the case. After we sit down, it's the last opportunity we have to speak to the jurors. And then the government's gonna get up and make another argument, trying to make you look like trash or make you look like the worst human being in the world. Once that happens, the jury then goes back and deliberates. That may take an hour. Fastest deliberation I ever had was 7 minutes. The longest I've had is about 15 and a half, 16 hours. And I've had acquittals and convictions on both sides, so that doesn't really tell you much. They're gonna go back, deliberate, and once they have findings, they're gonna announce their findings. We all come back into court, we sit down, the jury comes back in, and the judge asks them, do you have a verdict? And they say yes. They take a piece of paper, bring it up to the judge reads it, and by this time your fate's already sealed, good or bad. It goes back to the jury, and the most powerful moment of being a trial lawyer is about to happen. The most powerful moment ever. The judge says, accused and defense counsel, please rise. And we may be at a table, and I'm gonna pull one up since no one's sitting there. And we're sitting at a table here, my counsel will be sitting here, and it says, accused and defense counsel, please rise. So we stand up, I always button my jacket up, I'm actually wearing a tie, and you hold your breath. The juror, the president says, if everything went right. Of all charges and specifications, this court-martial finds you not guilty. And it's those moments where you hear the not guilty verdict where everything changes. Where all of the work that we've put in, or that your attorney has, through the investigation, referral, 32 referral, motions, hearing, and trials, all paid off, the hundreds or thousands of hours, and it was a not guilty verdict. That's what we're looking for. If it goes beyond that, we get into sentencing, and there's a sentencing hearing which comes very shortly thereafter, where your sentence is determined. But if everything's done right, we're looking for a not guilty verdict.